Assalamualaikum and good day to everyone. This is a review on the case of Maxwell against the writers of public prosecutions, which revolve around the issue of character evidence. So, a little bit about character evidence. It refers to a person's conduct or previous acts, his reputation among a group of persons acquainted with him, or his tendency or disposition to behave in a particular manner, including specific acts on his part. In this case, the appellant is William Maxwell, and he was a medical doctor and was charged and convicted at least assize of the manslaughter of a woman called May Holiday, and also of using on her an instrument with the intent to procure miscarriage. As a result, the appellant was then sentenced to 20 months imprisonment with hard labour. However, he was not satisfied with the decision of the court, and he proceeds to appeal from that conviction to the Court of Criminal Appeal, to which it was dismissed. During the trial, the appellant was asked by his late counsel on whether he has ever been convicted of any offence in his life, which was then denied by the appellant. In response to the questions asked, he further stated that he had a good, clean moral life, and upon his assertion that he had a good, clean moral life, the trial judge then allowed the prosecution to cross-examine him on another charge, which he had previously been charged with procuring an abortion, but then he had been acquitted of that charge. The issues of the case that I have come across is revolving around the character evidence. The first one is whether the prosecution had adduced evidence of the appellant's bad character when the prosecution questioned the appellant with regards to his previous offence, and secondly, whether that questions asked were admissible. The court, in considering the admissibility of evidence under the Criminal Evidence Act 1898, Section 1 under Proviso F, stated that it is subjected to the condition that it is relevant to the issue before the jury or as to the credibility of the prisoner as a witness. Hence, the court held that the questions asked by the prosecution were inadmissible due to the fact that the appellant had, as a matter of fact, never been acquitted on his previous charge of manslaughter. Therefore, the questions asked were not relevant to the issue before the jury, and as a result, did not have an effect of impairing the credibility of the appellant as a witness. Apart from that, the court has also repeatedly stated that if the appellant by himself has adduced evidence of a good character in order to show lack of propensity towards the offence charged, he then raises by way of defence an issue as to his good character. Thus, the appellant may then fairly be cross-examined to show the contrary. There are indeed many lessons that I have learned from the case, and it is from my understanding that generally the prosecution may not adduce evidence of the accused's bad character, even if it is relevant. However, through this case and upon thorough study, I have come to learn that there is in fact an exemption from the general rule that all relevant evidence is admissible, and this is clearly portrayed in the case of Maxwell's against TPP. In this case, an attempt made by the prosecution to strengthen his case when he asked the appellant with regards to his previous offence was not successful when the accused instead asserted that he is innocent. With that being said, I am of the view that the appellant's mere denial of an offence and assertions of innocence does not necessarily be construed as a good character. Thus, there should be a clear line that can be able to distinguish between mere denials as against assertions of good character. Another thing that I have learned from this case is that the prosecution should be more meticulous with regards to the questions asked to the appellant. For instance, in this case, it was noted that the prosecution had made a mistake when he sought to tarnish the appellant's character by asking about his previous offence in which he was not convicted, and in the contrary, was acquitted. And such acquittal would then be deemed as merely a misfortune and does not tend to show bad character. On the other hand, it would be different if the appellant had in fact been convicted of the previous offence, since it would be perfectly possible leading up to asking him in the first place whether he had been charged, because the question would then be relevant in this case. However, his question of "Have you ever been convicted of any offence in your life?" in this case was proven to backfire on him, when the appellant had, as a matter of fact, never been convicted. And in addition of that, the appellant managed to appeal himself in front of the court and the jury, and he asserted that he had a clean moral life, which shows that he had a good character. Thus, instead of aiming to prove the appellant's bad character, the prosecution had indirectly helped the appellant to give evidence of his own good character. In conclusions, in criminal cases, good character evidence is generally admissible, while evidence of the accused's bad character is generally not admissible in courts. In fact, under the common law, as per the case of Maxwell's against DPP, Viscount GLC stated that character evidence is one of the most deeply rooted and jealously guarded principles of our criminal law. Why? The basis for this statement is because exclusion of character evidence in criminal cases is due to its irrelevancy in showing guilt of a person, and the fact that the prejudicial effect of such evidence often goes against its probative value.